Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. And if you've just joined this channel, thank you for subscribing. And if you have any questions about foreclosure, if you're in foreclosure or you need some help, you can always send me an email. My email address is foreclosurehelp777@gmail.com. So today we're going to talk about the Fdcpa. And it comes up in just about every foreclosure case. So let's get started. Okay, so the verse of the day. Proverbs 18:13. He that answer a matter before he hears it is folly and shame unto him. Listen first, understand fully, and then speak wisely. Before accusing a servicer of violating the Fdcpa, obtain the records and understand the facts. Okay, guys, what is the Fdcpa? The Fair Debt Collection Practices Act is also 15 U.S.C. 1692. It's a federal law that regulates debt collectors and prohibits abusive, deceptive, unfair, and misleading collection practices. So the key point is not every lender, servicer, or foreclosure plaintiff is a debt collector, first of all. Common Fdcpa mistakes. Many foreclosure defendants allege that they don't own the note, the assignment is defective, the trust closed years ago, or the foreclosure is wrongful. While those may support other claims, they do not automatically establish an Fdcpa violation. Courts often dismiss Fdcpa claims that merely repackage standing arguments. So, what actually creates Fdcpa exposure? Potential Fdcpa issues include misstating the amount owed, demanding unauthorized fees, false representations about ownership, false payoff statements, collection letters containing inaccurate information, filing proofs of claim containing false balances, threatening actions not legally authorized. These are Fdcpa issues. Okay, so the focus often is on representation made to collect the debt, not merely who holds the note. The power of numbers. So many foreclosure cases involve payment histories, loan modifications, bankruptcy claims, escrow calculations, interest computations. A servicer can survive a standing challenge but still face serious questions of its numbers do not reconcile. Discovery creates Fdcpa claims. Don't assume that a claim exists, prove it. Here's some examples. You want to ask in your discovery, who calculated the balance? Ask who prepared the proof of claim if it's bankruptcy. Ask how interest was calculated. Ask for servicing transfer records. Ask for boarding records. Discovery often reveals the facts needed to support Fdcpa claims. Okay, so here's an example. A borrower discovered an original bankruptcy proof of claim and an amended proof of claim, and an approximate $49,000 difference between the two. The key question is, why did the debt change? If no one can explain the difference, this may become evidence relevant to the Fdcpa, bankruptcy, or accounting issues. This lesson, follow the numbers. Fdcpa and mortgage servicing. Questions worth asking. When did servicing begin? What balance was boarded? Who provided the boarding data? Was the balance independently verified? Were payments properly credited? Was the loan in default status when the servicer acquired the loan? Many cases rise or fall on these questions. So the general rule is this. If a servicer begins servicing a loan before default, it is often treated as the loan servicer rather than a debt collector. However, if a servicer obtains servicing after default, it may qualify as a debt collector and become liable to the FDCPA. Okay, example number 1, no FDCPA liability. The loan originated in 2015. The servicer acquires servicing in 2016. The borrower remains current until 2023. The servicer acquired a performing loan. The FDCPA may not apply. Example number 2, possible FDCPA liability. The borrower stopped paying in January. The loan was declared in default. The servicer acquires servicing 6 months later. The servicer acquired a defaulted debt. The FDCPA may apply. And also, if it says anything at the bottom of your statement from your servicer, it will tell you that this information is from a debt collector. Anytime you get those, that's basically them telling you that they are a debt collector. So if they're telling you they're a debt collector, then that falls under the FDCPA, no matter what. Discovery questions every homeowner should ask. When was the loan first declared in default? What records show the date of default? When did servicing transfer occur? What balance was boarded? And did the servicer acquire servicing before or after default? Documents to request: boarding records, servicing transfer records, MSP screenshots, loan setup records, transfer instructions, default notices, payment histories. These documents often reveal whether the debt was already considered in default, when the servicing changed hands. Why banks don't always volunteer this information? Because the answer can affect FDCPA liability, debt collector status, collection practices, and federal claims. A servicer may argue, "We are merely a servicer," and a homeowner may respond, "You acquired the loan after it was already in default." The least sophisticated consumer standard. Courts often evaluate communications from the perspective of the least sophisticated consumer. Ask, would an ordinary consumer be misled? Would the letter create confusion? Would the consumer be deceived about the amount owed? FDC evidence beats accusations. Strong FDCPA claims often include documents, letters, payment histories, proof of claim, internal servicing records, admissions obtained in discovery. Weak FDCPA claims often consist only of conclusions. So ask yourself these questions. Here's the FDCPA parts. If the amount is wrong, you want to look under 1692 E2A. If the letter is misleading, it's 1692 E10. If they are collecting unauthorized charges, it's 1692 F1. If they ignored a timely validation request, 1692 G. If they threaten something they cannot legally do, look at 1692 E5. If they engage in abusive collection conduct, look at 1692 D. One mistake pro se litigants make is alleging the FDCPA was violated without identifying which subsection, which statement, which communication, what amount, and what representation. So it has to be very specific. Judges tend to respond much better when a plaintiff says, defendant violated 1692 E2A by representing that the debt balance was $191,202.77 in the original proof of claim, and later representing it was $142,287.19 without explaining the discrepancy. There you go. That's how judges want it to be worded. And now let's talk about some case law. Cases where the homeowners prevailed. We got Goodwin versus Bank of America, which is a Florida case. This is a clear example of a homeowner victory. The court entered judgment in favor of plaintiffs Ronald and Deborah Gooden against Bank of America in the amount of $204,000. The court found that Bank of America violated the FDCPA by falsely representing the amount of debt and filing a foreclosure complaint in violation of the act. Okay, that was a good one, huh? So, next one. A Virginia case. Virginia. Yarney versus Ocwen Loan Servicing. The court granted partial summary judgment on liability in favor of the homeowner against Ocwen Loan Servicing. The court held that the plaintiff was entitled to judgment because Ocwen continued to attempt to collect a debt that had already been settled, violating 1692E2A of the Fdcpa by falsely representing that a debt existed when it did not. And then there's Vincent versus the Money Store. While this case was remanded for trial rather than final damages awarded, the Second Circuit vacated summary judgment in favor of the mortgage lender and established that the creditor can be held liable under the Fdcpa if it uses a law firm's name to send deceptive collection letters without the firms engaging in bona fide collection efforts. This is a significant procedural victory for homeowners and establishes a legal standard for holding mortgage companies liable. Then there's Renee McRae versus Federal Home Loan Mortgage. The Fourth Circuit reversed the district court's dismissal, holding that the substitute trustees and law firm involved in mortgage foreclosure qualified as debt collectors under the Fdcpa. The court ruled that their actions pursuing foreclosure constituted debt collection actively regulated by the Fdcpa, allowing the homeowner's claims to proceed. And then here's the last one, Gold versus Shapiro, DeCario, and Barrick, and we know that they are a foreclosure mill. The court denied the law firm's motion to dismiss, allowing the homeowner's Fdcpa claim to proceed against the firm for attempting to collect a time-barred mortgage debt. The court ruled that filing a foreclosure action on a known time-barred debt could violate the Fdcpa. So the Fdcpa is not a magic foreclosure defense. It is a fact-driven statute, and the strongest Fdcpa cases are built by obtaining records, following the money, identifying inconsistencies, proving false representations, presenting evidence rather than assumptions. The Fdcpa is most effective when it's used as a precision tool rather than a catch-all claim. Homeowners should focus on gathering records, analyzing account histories, and identifying specific misrepresentations concerning the debt, the amount owed, and the authority to collect. Courts are generally more persuaded by documented inconsistencies and factual evidence than by broad allegations. By approaching the Fdcpa through careful discovery and evidence-based analysis, borrowers place themselves in the strongest position to expose errors, challenges unsupported claims, and seek meaningful relief under the law. So the Fdcpa can work for a lot of y'all guys. Just have to write it good in your motions. And if you do have any questions, you can leave them in the comment section below, and I'll try to answer them. And thank you for watching my YouTube videos. And as always, everyone, God bless. Have a wonderful weekend.